I was already in Asia. I had moved from the Yale Law School, where I had been for 16 years, to the National University of Singapore, in the law school there. And I wanted to learn more about Asia. And Hong Kong University is a good law school to do so. Well, I visited here a couple of years ago, gave some talks and met people, and HKU law impressed me, most particularly because in my field, at least, my main field, comparative constitutional law, it's the best in the world. At that time, 2 years ago, there wasn't another university on earth that has as many good people. So felt comfortable. It's good in arbitration as well. I don't know the students very well. I just started, so I just finished my first class, and I don't teach undergraduates. And that's partly for strange reasons that I won't go into, having to do with scheduling conflicts. But mostly I teach LLM students right now. So I don't have a very good knowledge of what the undergraduates are like. But certainly at the LLM level, the best students are as good as any students I've had at Yale or Oxford or anywhere else. Oh, it's very, very different. I was at Oxford for nearly 10 years, and I had a special chair that I didn't necessarily have to teach. So I took graduate students and I taught classes, but the Oxford experience was one of a research chair. An independent research chair almost at Nuffield College in Oxford. And then I went to the Yale Law School, which is another very special place. It's incomparable to other law schools, even in the United States. So I don't know how to compare HKU to other schools, and I doubt that my experience here is comparable to my colleagues. Look, I think generally I'm interested in the process through which students transition from being students or receptors of knowledge, other people's knowledge, to being producers of that knowledge themselves. So that's the process I'm actually interested in. I'm interested in that for graduate students and also for upper division undergraduates. I think it's not an easy process. It's difficult, especially in law, where they're oftentimes taught that the law of the professor is the truth somehow, whereas I think of law as a set of perspectives and a set of arguments about what the truth's about. And I think it's difficult for students to move from the first to the second. I'm not sure I would call them hobbies. My life predates being a scholar. So I was always an athlete at a fairly high level, and I was a cook professionally, and I thought I was going to end up being a cook, not a scholar. And I'm a musician, and I was a musician before I was a scholar. So I've never given up those pursuits, and they're just built into my life. So I would say all of those things are more important than academia. How could it not be? Starting when I was a graduate student, I, in a very disciplined way, cabined off my academia in very precise times. So for one thing, I never take a vacation. I never have. I take no days off, including my birthday or Christmas. I work every single day from 3 to 4 hours, every day. And I'm usually done by noon because I start very early. And during that time, I don't answer the phone, I don't do email, I don't do anything else. So I think I get enough work done that way, but I'm basically done by noon, and I teach in the afternoons. And I do my email and administrative stuff in the afternoons, but that leaves me the rest of the time to do what I want to do. Well, I play traditional music, so this is music that's very old. It's unwritten. It's passed on orally through the ear. It's not, you don't arrange things. And yet everybody who plays this music at a sophisticated or professional level generates their own arrangements of these old tunes. And I play the tunes that I fell in love with for some reason. I wanted to be able to be a part of the tradition of playing them. That's the reason. But I think this is true for most people who play in this tradition. People know who played it before, and people know the stories that are attached to the songs, to the tunes. Every tune in traditional music has a story, a very old history, and many tunes are related to songs or to a particular place, or then in a memorial to a particular happening. So we always remember that whenever we play. And the liner notes of my albums all describe these stories in great detail. Do I have a favorite? I don't know. My most recent album, which came out last year, has a tune called Jimmy Sutton, which is a very old tune from before the Civil War in the United States, and lots of people play it today, but it features a conversation between a sheep, a cow, and a goat in the pasture. And so right now, and it's very popular on YouTube, so right now it's probably my favorite tune to listen to hear what people think, because people like it. My favorite book is called Invisible Cities by Italo Calvino. I love Calvino anyway, and I like the Diaries of Anais Nin. I don't read for pleasure. I don't read much academic work. I do that when I work, and I would recommend students do the same. That they stay alive by reading things outside of law or political science or whatever they study. And if they don't have time to read novels, you can always read poetry and short stories. Number one, I'm not a lawyer, so that's a dirty secret. I've been teaching in major law schools my whole life, and all of my research involves law and courts. But I've never passed the bar exam. I have a law degree in the normal sense of the term, and I'm not interested in practicing law myself. So I think it's very important for people who do legal research to be external observers, at least in my world of comparative and international, because most lawyers have a home legal system that they reflect and that they help to build and that they help to socialize their students into. And I don't have a home legal system. I do comparative international law. I work on systems that are not my own. I don't work hardly at all on the American system. I've written a couple of short articles, but I'm not interested in doing work on the American legal system. So I'm always an outsider, and I like that, partly because it's like travel. Comparative international law is like being in the travel log industry. You're reporting back what you see and what you're interested in, and it's unconstrained oftentimes by place. And I'm a permanent outsider anyway, so I'm here trying to make sense of Asia. That's a complex question too. What doesn't so much exist in Asia or in Europe are political scientists who study law. In the United States, public law or law is part of the political science field. It's a subfield of political science. And there's lots and lots of people who do it. So it's not very unusual. I am not really interested in subject matters or disciplines, so I work in the field of comparative constitutional law and international arbitration and human rights, courts, and a lot of theory and legal philosophy. But I don't do anything for very long. I have a tendency to change fields every 6 or 7 years. I get bored too easily. So I like to learn about new things that I'm interested in, but once I feel like I've learned enough about how that world works, then I'm not interested very much anymore. And this contrasts a lot with my colleagues, because there's a heavy pressure, I think, in the law school world to specialize, to do the same thing your whole career. And I don't denigrate that at all. I think that it's perfectly reasonable. What I do is unreasonable. I change fields a lot. But most people develop their specialty and keep adding to it as new materials appear. And that's not me. And part of the reason I do that is because I'm interested in more generic questions. I'm not very interested in specific legal questions like, if you were an American, what's the First Amendment and the free speech, and what are the doctrines, and what's the case law like, and what is the impact? I'm just not interested in those very traditional kinds of questions. I'm glad other people are, because I don't want to learn it myself, or I need people to tell me what they think is happening. And I oftentimes study lawyers as important political actors, as data. So I'm glad that they do that work. That allows me to do my work. But I'm interested in generic questions about how law and legal change works. So I'm particularly interested in how new legal systems are established and how they transform themselves, how they change over time. So most of the very different legal systems that I study are actually united in some ways because they have been fundamentally transformed by certain events or by a long set of accumulated developments. It's not really that I study so many different legal systems, although I study 10 or 11 or so. It's more that I study certain particular questions, and those legal systems allow me different cases of the same question. Yeah. I'm a political scientist, so there's a very old rule in the social sciences that you don't intervene in the affairs of other people's countries and other people's political systems. You don't come to Asia and tell the Asians what to do. You don't go to France and tell the French what to do, or to Italy and tell the Italians what to do. You go there to study it, and we're not always good at keeping those commitments, but we all know that they exist. Lawyers don't believe in those commitments. Lawyers are part of the political apparatus. They're for the most part never outsiders. They're part of the legal systems they study. Indeed, their very role is to rationalize and legitimize the legal systems of which they are part, and to socialize their students into those systems. They are, in some ways, the legal system, and that's why I study them. But I don't criticize them for doing that at all. Again, I study what they do as an outsider. What they do is interesting. If lawyers in a legal system start talking differently, then something's happening. They're indicators of something going on. If lawyers fight about something more than they used to, then that means there's something also going on. You have to take that seriously. So I take seriously legal scholarship because they're data about the legal system I'm studying, which is, again, very different than the way that most legal scholars study. I don't think most or do their research, I don't think most legal scholars study each other as political actors. Well, so I think that if I'm in Asia, and if I'm in Hong Kong in particular, I should learn about it. I should participate in research. And the Chinese have adopted a new Chinese civil code. It entered into force in January of this year, so it's new. After many attempts and 40 years worth, maybe 50 years worth of trying, they finally achieved this new civil code. And for any comparative lawyer, that civil code looks an awful lot like European civil codes, particularly the German the Dutch, in some ways the Italian and Spanish. And those civil codes, or the model that we're talking about, the German model, so to speak, has also been adopted by places like South Korea and is known very well in Taiwan. So what's interesting about the Chinese Civil Code is the question of what judges and the Communist Party will do with it. Why is this important? Because the civil codes in other countries, from Germany to Korea, have been what we call constitutionalized. That is, they become a part of the constitutional apparatus, and they've been instilled with rights and rights adjudication. In fact, the Chinese, as you all know, the Chinese have made their constitution unenforceable by judges. It's a non-justiciable document. However, it might be law, is non-enforceable by the ordinary judges. Meanwhile, they've created a civil code that has all of the most important and controversial rights that the West has. So they put in their civil code dignity. Why would they do that? Why is there a norm of dignity in their civil code if they intend not to enforce rights? There's provisions for equal pay for equal work among men and women and non-discrimination generally. The environment has rights to being protected. I could go on and on. There are also general clauses that come straight out of the German Constitution for good morals and general public order, which have been used by the German courts to further constitutionalize matters and to take a great deal of control away from legislators and in forging a partnership with constitutional courts. So what's interesting is that the Chinese have adopted on paper virtually all of the displays of constitutionalism that one has in the West, while at the same time saying, we don't want to do this. We don't want to go down that route. So the question then is, what happens? So what I'm doing is my project tries to look at this in 3 stages. The first stage is, what are law professors saying about the civil code? Are they debating constitutionalism? Are they debating judicial review? Are they debating the role of judges? Because the judges have made, the Chinese have made the civil code judicially enforceable. What does that mean? How can you make a civil code judicially enforceable but not the Constitution? Well, normally you can't. It's impossible. But like many things, the Chinese might have a way of doing it. The Chinese have a knack for finding their own way to doing things, and maybe they can do it in this way. In a place like Germany or in Europe, the revolution, the transformation of the civil codes, the constitutionalization of civil codes have occurred because there was a powerful commitment to rights protection and a powerful constitutional court that required the process. We don't have those in China. And so the question is, what are they going to do? So the first stage, we look at what academics are saying, and the second stage, we care about what the Supreme People's Court does with what judges are doing, or looks more carefully at judges, and especially the interpretations and guiding rulings that the Supreme People's Court and other judges issue. And third, we'll be looking at the legislature, the People's Congress, and the party as to whether or not they accept what's going on. So the key question is, now since China has famously shut down judicial review of the Constitution, the question is whether or not it will reappear as judicial review of the Civil Code. So I'm interested in that. And I'm interested in it as a question of Chinese law, but that Chinese law is informed by this larger comparative environment that's basically dominated by Germany. As I mentioned, the German experience is directly applicable, and it frames the Chinese experience. It doesn't mean the Chinese are going to follow the Germans. It's an open question. The Chinese might find their own way, and then we'll have an exception to the German rule. But everybody else follows the Germans, including Asians. like Korea. What we have now, though, is a Chinese party trying to perhaps negotiate a different way. So I'm interested in that, and again, the comparative materials frame what goes on in China, and I think it informs the way that we have to think about these issues. Heuristically, we say in English, as a way of asking the right kinds of questions and organizing our research, but we don't have preordained answers. I'm not a person who believes in preordained answers. We can ask questions and not know what the answers are. And if we get the questions right, we'll have something interesting to say in our research. And I think the Chinese Civil Code is where it's happening right now in China. I think it's momentous. So at first, I'm just interested in how the Chinese are now debating this. And it's been interesting to watch because there's a few people who understand what's going on and even discuss the German materials. But most people take the safe route, which is to say that, well, it's not going to really mean much in terms of rights and judicial review. And I just think that can't be true. If it is true, then if it turns out to be true, then I think we have something very interesting to study. Why is China the great exception? Why bother putting norms on paper or in the civil code that you don't intend to actually take seriously or respect? So we've entered a realm that's very complicated when we discuss methodology and what we in social sciences call research design. All scientists call it research design. So it's how you organize your research around questions, concepts, presuppositions, how you gather data to test hypotheses or to disconfirm hypotheses, and how you marshal that data into arguments meant to convince your audience that you're right. Lawyers, for the most part, don't do that don't organize their research in a self-conscious way, because these issues are largely already settled through traditional doctrinal analysis. Now, I don't want to, again, I'm not criticizing any colleagues, and HKU has large pockets of research that is social science oriented and not just purely doctrinal. But at the same time, most lawyers aren't trained in methods or research design. In the United States, you don't have to have anything but a JD, a 3-year law degree, to teach. Most don't. Nobody has a LLM. Nobody has a PhD. And nowadays that we do have people with PhDs outside of law, they go into social science, or they go into philosophy, or they do something else. They get a PhD. So the majority of people hired in the last 20 years at Yale Law School have a JD, often from Yale, and they also have a PhD in a cognate discipline. It took 7 or 8 years to do that. These are real PhDs. They're not PhDs in law. PhDs in law come from Cambridge and Oxford, and they're 2 years or 3 years affairs, and they do not feature traditionally any method or research design. So you have students being supervised and taught on graduate research by people who themselves aren't trained. In the United States, you do 3 years, 2 to 3 years, I did 3, of theoretical and methodological training. You don't have that in law. So this is a harder question to answer, and if you come from the social science world and a methodologically self-conscious world, then all those questions become very important. So obviously you have to have a theory or a range of theories that you're interacting with, and you use the methods, the data collection, data analysis that is the most conducive to testing your theories as hypotheses. That's how I'm trained. So I do this relatively naturally, but law professors don't. And you asked about students before. I mentioned the fact that students too have to graduate from being receptors of knowledge to creators of knowledge. And my last 3 books, which were published in 2017, 18, and 19 with Oxford, were all co-authored with my students from Yale. And I decided long ago, 25 years ago, that the best way to train students who were law students to become scholars was to integrate them into research programs with me as their co-author. They could see it happen step by step and learn how to write and learn how to present arguments, learn how to make arguments. And I hope that my students have benefited from that. They're all 3 of these students are law professors now, and I hope they learn something. But meanwhile, if you're in the United States, for instance, and you're in a PhD program in political science, which is, I'm a political scientist, you have a steady stream of graduate students, and you supervise their dissertations. And a lot of what that really means is that you're dealing with trained younger scholars who are writing a dissertation based on their training, and you're part of that training. But again, none of this exists in law schools. So you have to invent a new way of training students if you care about this. And my version of this is that students can choose to work with me or not. If they want to learn that sort of thing, they can. I'm here to help, but I don't require it and force it, and I don't require or force my colleagues to be trained otherwise. They all are trained in very different ways. So the second way that I try to help is that I teach a class I have for 25 years on qualitative methods for lawyers. So this is about research, how to design research and make causal arguments if you're a qualitative researcher. So it uses statistical analyses in the background, but it's basically for qualitative researchers, which is what most lawyers are, in fact. And I will teach that at HKU too, starting in January, and we'll see how many students enroll. It'll be open to every graduate student writing a thesis, and it will be open to any professors who want to take it. And in NUS and Yale, professors would regularly take the whole class as students. So it just shows how much demand there is for conversations about these issues. The first point to make is that I do not, you didn't imply, that I would say that quantitative or qualitative methods were superior to one another. And although almost all of the work that I do, I mix methods. I have a theory that can be expressed deductively and abstractly, which is a matter of logic, hopefully in more or less game theoretic kinds of terms, deductive theory. I have data sets that I've collected myself or access from other people, and I do quantitative analysis, econometrics, and other forms, which gives you a picture of the forest, but not of the trees. And I do a huge amount of very detailed qualitative work, which are case studies, where you get to learn about the trees in the forest. So I think that one should be able to combine multiple methods and approaches as pieces of the puzzle that you're assembling to try to answer particular kinds of questions. And that's what I would say. I think every method is good if it teaches you something about the problem that you're concerned with. The second point is that I was at the Yale Law School again for a very long time, for 16 years. And I'm a political scientist. And the Yale Law School invented what's called legal realism back in the 20s and 30s. And virtually every elite law school in the United States is dominated by legal realists. And what does legal realism mean for our purposes? It means that legal doctrine, classical doctrinal analysis is viewed as very limited. It's something we all know. You can't get a job at the Yale Law School if you don't know the doctrine inside and out. It's again a dirty secret to tell that my colleagues at Yale were the best doctrinalists in the world, but none of them believe doctrine really matters. The idea is that law doesn't have any intellectual content. That's an orthodoxy. It sometimes goes too far. And this might be shocking to say in a law school context that law has no intellectual content, but it doesn't. It's words on paper. So what makes law interesting, what makes it instrumental, what makes it work, real in the world, are materials from outside of the law. So you're a law and feminist, and you look at the law as congealed gender, you look at what it can teach you about gender, or it's law in economics, which looks at law in terms of efficiencies and the sorts of outcomes that matter to economic actors. Is it efficient? Is it inefficient? Should we replace the doctrine? And so on. You're a law and philosopher, so you look at the various classical philosophical questions about the law. You're a political scientist, and you look at the politics of the law, and so on and so forth. If you think about it, you will probably agree that most good work is about law and something else. And the problem maybe is that the something else has become more important than the law. And so that's why I say sometimes it goes too far. But again, it's important to realize that in major law schools, you have to know the doctrine. But you could probably never get a job, be employed, even if you were the best doctrinalist in the world, if you didn't know anything else. Now you could in Germany. You could in Italy, but you could not in the United States. And so there's big debates about how to do legal research. And it's true that in a place like HKU, there's still a commitment to doctrinal approaches. Again, I'm happy with this. Having people do good basic research on what lawyers and judges are actually saying is really important. And we forget that that's what lawyers and judges do most of the time, is produce words. So in a way, we're doing empirical work and we're doing outcomes when we look at doctrine, because judges produce doctrine. That's what they primarily do. So if we ignore that, we're ignoring what judges do. And I'm a heavy proponent of good doctrinal approaches. So the book that came out in 2019 on proportionality is an extension of a long article that was published in 2008 that I did with Judd Matthews, who was my student, and ultimately my PhD student in political science as well. So he got a PhD in political science from Yale, and he also went to the Yale Law School. And that article, 2008, that I wrote with Judd Matthews, is the most heavily cited article ever written in comparative constitutional law. I don't say that to toot my own horn, it's just the fact. It's an incredibly successful article because proportionality has taken over the world. And one of the reasons why proportionality is so important is that it's a non-deferential doctrine. It's a non-deference doctrine. So that's what we mean by intrusiveness. It's a non-deference doctrine. That means that courts can't hide behind what Commonwealth countries call Winsbury reasonableness or unreasonableness doctrines, or what Americans call political questions doctrines or national security doctrines. There are no doctrines that screen off the proportionality judge from doing rights adjudication. Proportionality doctrines are prohibited by proportionality. Whereas traditionally in the UK and in Australia, in New Zealand, in Hong Kong, judicial review was dominated by deference to political organs. Proportionality blows all that up, and that's why it's intrusive. Now, should proportionality be revised? In my view, no. There's no revision possible or useful or important. If you don't use proportionality, then you shouldn't say you're using it. You should use a more deferential doctrine, call it whatever you want. I have no brief for saying that every court should use proportionality. If they're using it, you should say it. If you're not going to use it because it's not deferential enough, you should say it. The Hong Kong courts, on the other hand, say they're using proportionality, but they're not, because they built unreasonable doctrines into proportionality. They built deference through an updated form of Winsbury unreasonableness into proportionality, and they call it proportionality. It's a complete lie. So that's okay if you want judges to lie about what they're doing. That's fine, and it might be that judges need to build deference into their right to adjudication in a place like Hong Kong. That might very well be. They're under a lot of pressure to defer to politicians when they do rights adjudication. So they should not use proportionality. They use proportionality because the British do it. The UK does it. The Canadians do it. And they cite to these courts. And as you probably know, it's related to international rights agreements, so they cite to the European Court of Human Rights and so on. But they do so wrongly. They know it's wrong. They know they're lying, but they do it anyway. So I've written about this. I wrote an article for the Hong Kong Law Journal last year showing how the Hong Kong courts misappropriate and misrepresent what they're, misappropriate proportionality and misrepresent what they're doing. And I think it's bad for them. They don't listen to me. Why should they? They're going to do whatever they want to do. They're Hong Kong judges. They already have a difficult job. It's one of the most difficult jobs in the whole world, being a Hong Kong judge. If I was a Hong Kong judge, I might misappropriate and misrepresent too. Don't get me wrong. Again, I'm an outsider, so I say things bluntly in a way. I don't think a Hong Kong lawyer would talk the way that I do. But I'm not a part of the system. And I think this is not good for the system, and I've said why in my article in the Hong Kong Law Journal. At the same time, I hold no brief for expanding the domain of proportionality. Again, if Hong Kong courts don't want to use proportionality, they don't have to. They could just say, we're going to keep doing reasonableness, or we're going to keep deciding willy-nilly on a case-by-case basis what's reasonable and what isn't reasonable, which is really what they're doing. What they're really doing now is just deciding when some things are too politically sensitive, and then they say, oh, we're going to be deferential. And when it's not too politically sensitive, they say, oh, okay, we're going to do real proportionality. But what they're doing is not applying proportionality. So I don't believe that proportionality should be changed. I think that judges should be honest about what they do. And is it hard for some judges to adopt proportionality? Yeah, it's really hard, because it means openly admitting that you make policy choices, that you monitor and supervise what political officials do when they make policy choices. That's the whole point of proportionality. If you don't like that, that's fine. If you want legislative sovereignty, you don't want judicial review of legislative acts, then you don't have to have it. Nobody's forcing you to. That's different for the UK. The UK has a Human Rights Act, as you all know, from 1998. And slowly, one of the things the Human Rights Act says is that judges in the UK must abide by essentially the basics of the jurisprudence of the European Court of Human Rights. And the European Court of Human Rights says the failure to use proportionality means automatically a violation of Article 13 of the Convention, which states that everyone has a right to an effective judicial remedy. Proportionality is an effective judicial remedy. Winsbury unreasonableness is not an effective judicial remedy. In fact, it generates a violation in and of itself. If the British don't like that, they should leave the convention. That's all. I'm very hard about this because I just don't think there's nothing to debate on this question. You can't say, oh, well, let's build more deference into proportionality. It's not proportionality, then it's something else. So the British are in a tough spot. And you might have noticed that last week, the British Prime Minister, Mr. Johnson, floated again the possibility of rescinding the Human Rights Act, getting out of the European Convention on Human Rights. Maybe that's the best option for them. It could be. Meanwhile, New Zealand, which also doesn't have judicial supremacy, uses proportionality. So does Canada. So do every effective court in the world that protects rights has adopted proportionality, including in Taiwan and in Korea, and increasingly in places like even like Singapore. So if you want to be on the wrong side of history, you can be the Brits. On the other hand, Hong Kong is not obliged. Their rulers are in Beijing, and there's no reason for anyone in China to accept proportionality, because they don't accept judicial review on rights grounds. Once you've said that you can't challenge a legislative act in China on rights grounds, it's over. You're done. There's nothing else to say. We can discuss if that's good or that's bad, and there's advantages and disadvantages, always. But there's nothing to talk about with proportionality. So we don't, what we do here though is we try to adapt proportionality to these circumstances and pretend that that's what we're doing. And some of my colleagues seem to agree with the Hong Kong courts on this. But again, that's because if the Hong Kong courts do something, then some of my colleagues have to try to show that it makes sense. But they don't. They can just simply say it's something else. Be honest about it. Johannes Chan, who was of course is a former dean here, has written very straightforward articles saying the same thing that I did. So we agree on this point, at least. So executive authority in the state has been in steady expansion since at least the 1860s. This is nothing new about it. It's been steadily expanding since the 1860s, and it expanded doubly so in the 1930s and 40s and 50s. So this is a secular trend. It's not going to go away, and yes, it's going to become all the more important. So it raises a basic issue, which we call accountability. How do we hold government accountable? How do we know, why do we trust government when they act in our collective interest, in the public's interest? That's the problem. And we have a basic solution to that problem. And that's that you give individuals and companies, for that matter, and groups, the right to bring an action against government to a third-party dispute resolver for determination as to the legality of that measure. That happens to be dominated by proportionality right now in administrative and in constitutional review. I'm entirely in favor of that. It's the only solution possible. If what you care about is accountability, you have to have a third party dispute resolver. We oftentimes call those courts or judges, to whom one can bring actions, raising the question of the lawfulness of state activity. We already know that. There is no alternative to third-party dispute resolution. That's why the conversation is always about judicial review. Can't be anything else. So, you know, in theory there might be another system, but that's not the world that we live in. The world that we live in becomes increasingly narrow. And possibilities are narrowed. And the institutional techniques and repertoires that exist in the world have narrowed. And everybody copies each other and does the same thing. So the answer to your question is the same in virtually every country. It's not even that there's any doubt. Now, China disagrees because they know what the answer is, and they've basically said yes and no. So the no is pretty obvious. They don't have constitutional judicial review. On the other hand, China has for the last 25 years, with market building programs and so on, has relied very heavily on administrative law and courts. and what we would normally call rights review, because China is a vast state. It's huge. It's a vast empire. No party can really control it. So one of the solutions that makes sense, if our question is how do we control what's going on among citizens, but also what's going on among the rulers of the party, or the far-flung rulers of the party and that are now in place in distant provinces, how can we know what's going on? Well, one of the nicest and easiest ways to monitor and supervise the activities of citizens and rulers is to allow court actions to appear. It's the easiest way for the party in Beijing to even understand what's going on in far-flung provinces. So the Chinese have embraced law and courts and judicial review in ways that they did not 30 years ago. So it's happening even in China. The big fight that goes on there, though, is about judicial review of the Constitution, not about administrative law or about judges and courts more generally. I think that the Chinese will increasingly rely on judges and courts. There's no real choice. Yeah, well, probably what I say won't make me any friends, but I think that young scholars should ignore a great deal of what they've learned and attempt to follow their interests wherever it takes them, especially if it is contrary to what their favorite professors teach or what they've learned. They might be wrong, but that's the only way to learn that you're wrong, is to pursue it relentlessly. It's very hard to do good scholarship, and it's in law, and it's very hard to even write one good paper. And it's even harder and longer, more grueling, brutal almost, to write a doctoral dissertation or a book. So if you don't love what you're doing, if you're not passionate about the questions, it doesn't make sense to try. It's better to be a cook. It's better to get a normal job outside of academia than to torture yourself within academia. So to do good scholarship, you have to really be passionate about the underlying questions, and you can't let anybody or any obstacles get in your way. My advice, of course, contrasts with what a lot of students think they know, which are to take their advice of their professors and do the safe thing and play the game the way it's supposed to be played and care about your grades. I just don't care about any of that. So I think that people should pursue their passions just like in any other kind of field. You need that even more so in scholarship.